Hello, and thank you for joining us for a special one-off episode of the Environmental Essentials webinar series. And today we're going to cover EPA's recent proposal to amend the Federal Risk Management Plan, or RMP, rules in 40 CFR Part 68. This is Whit Swift with the Bracewell Environment, Lands, and Resources team. And I'm joined today by my colleague, Stephen Cook, who recently joined, or perhaps more accurately, rejoined the Bracewell ELR team in Houston after a number of years working as EHS counsel for a major international chemical manufacturing company, and then after 3 years of distinguished service as the Deputy Assistant Administrator of EPA's Office of Land and Emergency Management. We have a lot to cover this morning and only 30 minutes to do it, so we're going to dive right in. I'm going to give you an extremely abbreviated introduction to the RMP program and to the recent history of EPA's efforts to change the program. We'll then review the proposed changes to the program that we believe will be of greatest interest to the regulated community. We're not going to cover every aspect of the proposal, but we'll hit the highlights. And on those topics, we'll get some insight from Stephen based on his experience about the significance and potential impact of those changes if they become part of the RMP program. Last, I'll quickly summarize the path forward for the proposed rule. The RMP program was established under Section 112 of the Federal Clean Air Act. It's focused on the prevention of accidental releases of hazardous air pollutants and the response to such releases when they occur. You're subject to the RMP rule if you're a stationary source and you have a process that contains a threshold quantity of a regulated substance. With its focus on the prevention of accidental releases, the substantive elements of the RMP program, at least for those Program 3 sources, which are the largest and most heavily regulated, those requirements mirror the prevention program requirements of OSHA's PSM, or Process Safety Management Standard. The difference being that the OSHA PSM standard is focused on protecting your employees, while EPA's RMP program is focused on protecting your neighbors. Now, sources that are subject to the RMP program must prepare and submit to EPA a risk management plan that evaluates potential release scenarios and describes the source's prevention and response program. And those elements of 40 CFR Part 68 are requirements that the RMP plan and the RMP program must meet. And that's really all the overview we're going to get here this morning. We got to keep moving. Jumping quickly into recent history, it's a bit of a tortured one, and the program has been a bit of a political football. You may recall that EPA undertook a lengthy process during the Obama administration, triggered in part by the deadly fertilizer explosion in West Texas, that eventually resulted in a wide range of changes being adopted to the RMP rule in the very last days of the Obama administration in January 2017. The Trump administration then pursued a variety of legal avenues to stay and delay the implementation of those changes, while at the same time engaging in a reconsideration proceeding that culminated in the 2019 RMP reconsideration rule. Without going into much detail and oversimplifying what happened in 2019, that reconsideration rule generally retained a number of the changes from 2017 regarding emergency response planning and exercises, but it largely rescinded the 2017 rule changes that were aimed at accident prevention. So here we are in 2022, a Democrat back in the White House, and we've got EPA revisiting the RMP rule and proposing a new rule package that includes a number of items from that 2017 rule that were dropped as part of the 2019 reconsideration. And Stephen, before we get into any specific program elements here, I wonder if you have any thoughts on EPA's general approach and what they've done in trying to incorporate some, but not all, of those elements of the 2017 rule.
Thanks, Whit, for that introduction. And indeed, I think it's important for people to look at the evolution of EPA's analysis that underlies these three different rule packages. If you look closely at 2017, there was a lot of language in there about it was EPA's belief that these would make the world a better place. There is no empirical study that shows the RMP rules have actually had a real measurable impact on whether there are fewer accidents or not. There's a belief for that. But there is no study that the agency can hold on to. In the 2019 reconsideration rule, the agency relied heavily in data analysis of the RMP release reports and started bringing that to its thinking about what should or should not be in the RMP rule. In the latest version now, they have, rather than just ignore what was done before and go back to 2017, have actually built upon the analysis done in 2019 and done a deeper dive into the underlying data and trying to provide some analytical justification for these rules. So it'll be interesting as we go through to look at how they have done that.
And actually, one other thought before we get into the substantive elements, but an interesting point is all of us that have been following what EPA has done since the 2020 election, it's all about climate and environmental justice. And EJ is an obvious issue for the RMP program. And it's one that, from the very start, we anticipated that we would be revisiting the RMP rule as it would be a win that the administration could hand to folks that were promoting environmental justice. But it's interesting that there's also, they've sort of shoehorned some climate aspects into this, and we'll get into some of those. But even here in RMP, this administration's focus on not just environmental justice, but also climate finds its way into this program about, preventing accidental releases of hazardous air pollutants. But with that, hey, let's get into the substantive program elements that EPA is proposing to change. First, we're going to review some of those proposed changes that relate to the accident prevention part of the program. Okay, so here's our first one. Under the RMP program, Program 2 and Program 3 sources conduct these hazard reviews. For Program 3, for Program 3 sources, they're the formal process hazard analysis, or PHA. The rule already contains a list of topics and considerations that must be addressed by the hazard review or the PHA, again, depending on whether you're Program 2 or Program 3. And the proposal would add that these reviews must address natural hazards, including those caused by climate change, as well as standby or emergency power systems. So here, right off the bat, is this example of climate being shoehorned into the RMP program. But in my question, Stephen, for you and more in general is, so now we've got this explicit obligation to take into account natural hazards and power loss, particularly for those folks here in Texas along the Gulf Coast. That's an area of particular concern. Curious whether you think that this obligation to address those natural hazards is something that the Program 2 and Program 3 sources, is that going to be a new burden for those folks, or do you think they're doing it already?
For those who already had a good program in place, this will be nothing new. When I was at EPA, I constantly reminded staff and those who criticized us, we were agnostic as to why there was a storm. Storms needed to be addressed. Loss of power needed to be addressed. This has been an ongoing issue for decades. In one of my prior lives, I had an agency request that I put a backup power plant next to my facility so that I could turn that on if the regular power plant went off, which is a little expensive and a little impractical. But this issue has been around and needs to be addressed. The one slight additional change is there might be other areas, and later on they talk about assessing whether you're in the floodplain or such. And with the new maps that have come out and perhaps bigger storms, people who maybe had not thought about losing power because of a storm, they might be pulled in. But loss of power has been something that should have been part of your hazard review all along.
All right, next is another change to the hazard review process, and that is that the hazard reviews for certain facilities will have to include, under the proposal, a Safer Technologies and Alternatives Analysis, or STAA. This is an analysis of inherently safer systems. A couple interesting wrinkles to this one. First, there is limited applicability of this requirement. You can see there on the slide, it applies in the PHA and to Program 3 facilities only, but not to all Program 3 facilities. It's to refining and chemical plants that are located within 1 mile of another source that is also a refinery or a chemical plant, and also to specific petroleum refining processes that involve the use of hydrofluoric acid in an alkylation unit. But again, if you're one of those facilities or sources or have that type of process, there's going to be this new requirement to look at inherently safer systems as part of the every 3-year PHA. Curious, with this obligation, Stephen, to look at inherently safer systems as part of the PHA, for those that are going to be caught or brought into this new requirement, do you expect that to be a big change as to how they conduct their hazard reviews?
For many companies, this will not be much of a change. The principles behind inherently safer of designing away the problem or reducing the input of employees having to make an effort to put in the safety system versus automatic controls, all are part of a good PHA analysis already. The interesting aspects of this is actually the underlying justification EPA put together. This is part of their additional data analysis, and they found that the accident rates at refineries and chemical plant RMP facilities is higher than the general average of RMP facilities. So that's part of their justification for this. The other aspect that makes it very interesting here is that looking at where you're located as to regards to other RMP facilities is, I think, another effort to get, as you mentioned, the EJ aspect of this program. The agency currently is pushing hard on multiple facilities impacting the same community, and that they want to relieve that burden or keep it from increasing. And so this is a justification they've used for this within 1 mile, the cascading effect in their minds of an accident at one facility perhaps impacting another and causing it to then also have an issue that it documents or impacts the community. The other issue, the documentation of this analysis, and then ultimately in the public availability aspect of it. Companies are going to need to be careful about how they write this up in their justifications and recognize that it's going to, if this goes in place, the intent is for those kind of decisions, whether to implement or not, are going to be made available to the community.
Yeah, that point you made about just making this program more burdensome, establishing additional requirements for sources that are located in heavily industrial areas with similar neighbors. That's something you see in a couple places. But yeah, that is, it seems like that's a lever that EPA is using here, is making life a little harder for folks in certain source categories that also have industrial neighbors. So transitioning, Stephen, and actually using your point about the location of the source, and that being part of this safer systems analysis, there's also a change to the hazard review process that deals with siting. And the rule currently already lists siting as a consideration, but the proposed rule would make it explicit that this is not just on-site siting, that is, where your control room is vis-a-vis a certain process or sphere, but rather that the siting considerations for hazard reviews are to take into account hazards posed by proximate facilities and also the accidental release consequences posed by the proximity to public receptors. So, this aspect and this more explicit description of what EPA wants you to do with regard to siting in the hazard review process. Is this, in your view, a big change as far as what these folks will need to do either in their PHAs or their hazard reviews?
Once again, a company that has done a good facility siting analysis, this will be nothing new. The look across the fence and see what you're doing on the outside impacts should have been part of that in many cases, you're far enough away that it wasn't. But once again, you see EPA really emphasizing that community impact and taking a look at that. And so as advice we constantly give to our clients is to make sure you walk your fence line and know what's there, look both at what's across the street, and also look at your own facility, the way they view it and such, and take those things into consideration as you're making decisions.
And that offsite analysis and recognition of who's on the other side of the fence is particularly relevant for this next slide. So this slide, under this slide, it's a new requirement that is to where it's really sharing your analysis of some of these recommendations that you get under the program. So the idea here is that the plan itself has got to include the source's justification when it does not adopt a recommendation that flows from a hazard review or a PHA or a third-party compliance audit or a recommendation from related to any of these issues. That is power loss, hazards, siting considerations, which now takes into account your potential public exposure. And again, as also any recommendations you get if you have a third-party compliance audit. And so this is an interesting one because here you've got this obligation to include when you decline to implement a recommendation that flowed from one of those, either a third-party compliance audit or any of these other analyses. You actually have to document and explain why you did it, and it will become part of your RMP, which is publicly available. Curious your thoughts about this requirement, whether or how it might have kind of a chilling effect on some of those processes when you have to publicly explain and state, I guess sort of acknowledge that this was recommended and you're choosing not to do it. This seems like it could be a pretty significant one as far as sharing with the public kind of your risk analysis here. Curious your thoughts on this aspect of, it's kind of a cross-cutting issue, I guess, because you're looking at recommendations from a number of different program elements, but the crux of it is sharing with the public your evaluation of that level of risk and what you're willing to take.
Well, a theme throughout this rule from EPA is that they are looking for your employees and your community to also assist EPA in overseeing your RMP program and having some input into it and holding you accountable that you indeed are considering these other alternatives. Things can be important for companies to think about how they write up their justifications and consider actually putting into the RMP the recommendations that they did take. So as you present a picture, if you got from a PHA 7 different recommendations and you did 6 of them, but one you didn't, if you just put the one out there that you didn't do, it sits there in isolation and it gives people the impression you may not care as much as you do. Whereas if you put it in context of the 6 you did take and why this one didn't, whether it's for technology or duplicativeness because you did these other things, it provides more context. I think that's something that companies need to think about. Legal departments are going to have to get more comfortable with more information getting out to the public before an accident happens. All this is the type of documentation that ultimately comes out if there is an accident and there's lawsuits and discovery. If you will, this is kind of pre-filing that discovery in these contexts.
Indeed. So let's transition here, continuing to talk about audits for a bit. That previous slide was about sharing information or sharing your analysis as to whether or not to implement a recommendation flowing from a third-party compliance audit. That is an aspect that was in the 2017 rule that is back in this proposal. And the idea here is that in certain circumstances, the source will have an obligation to do a third-party compliance audit using an auditor that meets these specified independence requirements the next time their compliance audit is due. And the rule specifies certain triggers for conducting that third-party audit, 2 RMP reportable releases, and that is an RMP reportable release. Remember that that's different from, say, a CERCLA reportable release, but you're talking about the type of release that would trigger the need to update your RMP to address that release or describe it. But so if you have two RMP reportable releases within 5 years from a covered process, or a reportable release from a covered process at a refinery or chemical plant that's located within a mile of another. So there's returning to that issue again of just making this program more complicated to implement and more difficult based on citing, and not just citing to not citing to sensitive receptors, but actually citing to industrial receptors. And then the third one, which is the one that I remember this from 2016, 2017, causes the greatest level of anxiety in folks reading the proposal, which would be, that third party audit could be triggered if the implementing agency, which in most cases will be EPA, requires it because they feel that there are conditions that could lead to an accidental release of a regulated substance, which seems potentially very broad in my view. And then this was another aspect is and the rule site is here on the slide, there are specific independence criteria for the auditors. And I know that this was one that caused a lot of concern back when the 2017 rulemaking, and I think they've made some changes to address it. But Stephen, curious your thoughts on a couple things here. One about the third party audit triggers, but two, this independence criteria. Do you feel like, this obviously represents a bit of a change from what was adopted in 2017. Curious your thoughts about, how this looks based on the changes and the key differences from what was adopted in 2017.
Well, they've narrowed down the applicability of it. And once again, pulling in that data analysis of focusing on the chemical plants and refineries. So there's nothing really new there that we haven't already talked about. The third criteria that implementing agency requires, you're right, it's very broad. When you work within the agency, you find out that they see the whole panorama of sources, the sources that do it well, sources that try but don't quite get it right, and the sources that are really badly run. And so if used properly and with good judgment, that's probably an appropriate thing for the agency to be able to say, hey, you look pretty shabby. You really need a third party to help you get your program up to the. And we had a lot of discussions when I was at EPA about how do we get the bottom up? Those at the bottom tier that weren't performing well, we're ignoring the program. How do we get them into it and doing some basics and trying to, to improve their performance in that regard? The independence criteria, I do believe they've listened, they've tried to fix it. It'll be interesting if companies really think and auditors really think they have, but the universe of available auditors is much larger now than what it would have been under the 2017 rules.
Yeah, and I can see your point there. It's interesting because you want to, as far as that agency discretion trigger for those audits, the real challenge, I guess, is writing it broad enough to capture those circumstances that you describe where the agency views somebody that's really that's asleep at the wheel, not implementing a good program. And how do you write it that captures those that would give others certainty or more confidence that it wouldn't be implemented, for somebody who's really making a good faith effort at implementing a sophisticated program. And so I understand the challenge there, and it is one where, threading that needle has got to be a real challenge.
Yes.
Okay, shifting gears to another element of the program here about the incident investigation requirement. And they have proposed some changes to incident investigations for both Program 2 and Program 3 sources. Specifically, it's that specifying that incident investigation report must include an analysis of factors that contributed to the incident, including root causes, and that this root cause analysis must be conducted using a recognized method. I'm curious, Stephen, your thoughts. This was one I recall us discussing this at 2017 when this was in that rule package. and this requirement to conduct an RCA using a recognized method as part of that investigation. Would you think that will be a significant change or expansion to what companies normally do for their incident investigations?
Good incident investigations already do root cause analysis. I think the prior controversy was with the way they had written it, is that it was using language that you could argue eliminated some of the techniques that were used. And I think this is an attempt to write it in a way that tries to, if you've got to recognize it, something that's out there that lots of people are using, you should be fine. If somebody's got the unique proprietary way of doing things, I think they're the ones who may have to just kind of look at this and see that it fits within the language that's put out there.
Whether their method qualifies or whether they're comfortable, deeming it a recognized method that would ensure compliance. Okay. All right. Our next topic relates to employee participation and new employee participation requirements that EPA is proposing to include in the rule. There are a number of requirements here that, as you can see on the slide, apply to both Program 2 and Program 3 sources that involve the development of written employee participation plans, providing an anonymous compliance or hazard reporting mechanism for employees, and for Program 3 sources, explicitly including a requirement that they have stop work authority for those and a process for evaluating those requests to stop work. And then last, also for Program 3 sources, there's an explicit obligation that the source consult with employees when it comes to resolving PHAs, incident investigation reports, audits, and the like. So the proposal clearly beefs up the regulatory side of required employee participation in these program elements. Which of these topics, Stephen, do you think are a big deal? Which might change the way people have been running their program if they're adopted as proposed?
For companies that already have good programs, employee participation has been part of that. And if you read the preamble language underlying this, even on the stop work, there are ways to cobble together your other mechanisms you have to meet this requirement. So I don't think this is a new thing for sophisticated programs. It's for those who may not have a robust program that this will look fairly daunting. So I encourage them to read through knowing the rule language, but the preamble, and ensure that their processes will fit within that parameter. But this is, once again, this EPA really wants to ensure that employees have a strong voice and are acting as a check on management to ensure that process safety issues are being addressed.
Shifting gears here from the accident prevention part of the program to emergency response part of the program. There are proposed changes related to emergency response and specifically community notification as part of that emergency response. And here, the rule language states that both responding and non-responding sources have to develop and implement procedures for informing the public and response authorities about accidental releases of RMP regulated substances. I've included the citations here on the slides. You can see those are for Program 2 and Program 3. And there's this obligation to assure that a community notification system is in place, and that there are these procedures in place that will notify the public when such a release has occurred. What do you think about these new community public notification requirements that EPA is proposing to include, Stephen?
These are good enhancements. The one that potentially is problematic is this community notification system. We had debates when I was at EPA. Not all communities are the same. And you have the Houston Ship Channel has all sorts of exercises, integration between the facilities, emergency responders, not a problem. You have the rural setting that is one of the issues with West Texas, where you had volunteer fire department dealing with an RMP type facility. And that's where you're going to have some of the issues. Some community emergency responders, they want control of their public notifications, their responsibility. Others will gladly take the help. And so you're going to have to really work with your local emergency responder, your LAPC, if it's even functioning, If it's not, try to get to function. And I encourage companies who have those concerns to really voice those to EPA to make sure that they're not being put in charge of the public notification system, but that they have access and are working with whoever is the entity responsible for the public notification, that it will work when it's needed.
Yeah, that's a good point, because ultimately, if a third party or a local responder is the one that is going to be providing that alert or notification, but the company itself is the one that's got the legal responsibility to do it under Part 68, that does create some concern there based on the sort of sophistication and capability of the body that has taken on that alert responsibility. The last substantive element here that EPA is proposing to change, that we're going to discuss in at least any detail, relates to the public availability of RMP program information. And there's a specified list of information and data that is required to be available to the public. That includes the regulated substances that are present in their safety data sheets, the accident history, information about the emergency response program and emergency response exercises, and the LEPC contact. And the source has the obligation to provide this information to certain members of the public upon request. A couple of interesting things that are in the proposed rule about this element. First, EPA's effort to try to limit the folks who have a right to this information. That is, members of the public who reside within 6 miles of the source. The other EJ issue I think that you'll see there, again, EJ stuff, creep, is all across this, but here's an example of it, is that you've got to provide that information within 45 days, and you've got to provide it in the language requested. That could be a challenge depending on your capabilities to translate and how many different languages you might have in the 6 mile radius of your site. And there's this obligation to have, either on your website or in some other place, an ongoing notice that says, okay, anyone from the public, we have the obligation to and will give you this information upon request. I know this was one, Stephen, in 2017 that caused a lot of heartburn for the regulated community, and trying to balance those concerns about security and safety with sharing important information to the public. What do you think about what EPA has tried to do here in the 2022 proposal?
It's good to see that they recognize that there is a security concern, and they are trying to reach some kind of appropriate balance. I'm not sure how realistic the 6 mile limit really is with the internet and the ability to move information around so easily. And they do make a good point that a lot of the information is already out there. So those who have concerns on security really need to take a look at what is the information that is going to be required that isn't already out there in some form or fashion. And does this still present the security concern? The 6 miles is based on, once again, a data analysis of potential impact zones from various RMP plans. So there was an effort to use the data available to them to come up with something. This is one I think they probably have landed in it's an interesting place. There's not a perfect solution to the balance between security and publicly available information. So I think that's one that if there's a really particular concern of a particular type of information or such, somebody needs to get that into the record in great detail to try to bolster that to the agency. I think we'll give it a fair consideration. If how they solve that problem may be difficult to come up with, but it's important for people, if there's really a piece of information that presents a real security concern in their situation, to get that into the record for the agency to consider.
That absolutely seems like one of those issues where they're not going to be able to make everyone happy.
Yeah. And
they're just, you can see here, they're trying to land on some compromised position that will make no one happy. And maybe that's where they need to end up. That's the last of our real discussion of substantive topics here. And I know we've run over, so there are a few other items in the slide deck that we put in for sake of completeness. Let me just run through those real quick. Please feel free to reach out to me or to Stephen if you'd like a copy of the slide deck or have any questions about the other information on the slides. But let me go through this real quick just so you can see it. So this slide reviews a handful of other topics, including record keeping for hot work permits, emergency response exercise frequency, near miss definition, some other things that EPA has raised in the proposed rule that we didn't discuss in any detail today. This slide reviews what EPA has proposed to be the compliance deadlines for the proposed changes. The information is there on the slide. I'll let you look at it and read it at your leisure.
One comment on that. That was a real issue with the 2017 rule. Nobody knew exactly when things got triggered, and the agency learned. So here they've tried to be very explicit about when each provision comes into play and how it works. You'll see a lot in the preamble about reliance on the 2019 rule and trying to deal with that. So this was a good faith effort by the agency to be very clear about when things are required to be done. So people just take a look at that and see if it is doable. And if it's not, make sure you get that into the record as well. But I applaud the agency for trying to be clear about when these actually will roll in. And that's something they didn't do in 2017.
And thanks. Yeah. And there's an interesting aspect there you'll see about the field exercises where they've tried to, make sure you get, if you've gone ahead and done a field exercise under the 2017 rule, to give you credit for doing it as far as when your next one is due under their 10-year cycle. But yes, there are the compliance deadlines under the proposal. And last here, just some basics about the proposed rule and the path forward. There's the Federal Register citation if you'd like to find this, the full proposed rule in the Federal Register. There are virtual public hearings set that will take place at the end of this month. The information on how to participate in those hearings is included in the proposal, the Federal Register document. And last, the public comment period on the proposed rule closes at the end of October. I know that there has been at least one comment filed seeking to extend the public comment period on this proposal. Haven't seen any action on that yet, but as of now, the comment period closes on October 31st. And that's it. Thank you for joining us today. Thank you for bearing with us when we ran over a few minutes. And please be on the lookout for the next episode of Bracewell's Environmental Essentials webinar series. And importantly, we hope to see you on November 15th at the fall edition of our Environmental Law Seminar, which will be in Houston. Thanks again for joining us, and we'll see you in November.